So this is a case that it's actually filed in the Karen Reed case. This is, you remember Lank, Officer Lank? I think he's a sergeant or detective now. He committed perjury on the stand. I don't know if you remember, but this is just an example. Like, I know a lot of people are like, all the cops were lying, right? But this is very specifically, the reason I'm sharing this is because this is just an example of how many people, if they're doing this to somebody who's resourceful to be able to get a good team of lawyers and expert witnesses, what are they doing to poor people or minorities? Or, so this is the case that I don't know if Link thought that these didn't realize that they knew about this case, but Link lied on the stand when he brought up this case about him assaulting and attacking and then lying on these people just to show an example of how they operate. And he tells his version, that he was the one that was assaulted, and then he's like, well, that's not what they said. And he's like, well, I don't know what their version of the event is. I wouldn't have any idea what their version is. Were his exact words. And that is a lie. So when he brought up about the federal lawsuit, I mean, he just casually lied to the whole world on live streamed freaking television that he didn't know what these guys' complaint was. He didn't know what their version of the events was. And this is a United States District Court for the District of Massachusetts. It's going to tell you their story, because these brothers, Mark Lopalato and Alfredo Lopalato, are just classic example of there are so many more other victims. And this isn't just about Karen Reed. It is about justice for John O'Keefe, and also justice for Karen Reed and her family, who have been they've spent their whole life fortune or more. She's lost her job, she's lost her income, she's lost her insurance, and her medical insurance is what this family has been through. Keefes are not the only victims in this scenario. The Reeds are also victims because their daughter has been attacked, and they've had to use everything that they could possibly come up with to just protect their daughter from this continued onslaught of attack, as the Keefes attacked her in the courtroom with their hatred of her, continued hatred of her, even in the light of the evidence, that praying that they will come and see. I know they're grieving, but they're sitting there with these people who are demonically, horribly lying, and you can see now the evidence that they're lying, continuing to not rise up and say, hey, it appears the state is lying, but you have to give the Keefes time to come out of their being deceived by the state. Okay. And there's many, 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 many thousands of people in the history of the United States whose family members, their loved ones were lost. And there was 100 people exonerated off of death row when the DNA test first came out. When they first came out with the DNA test that exonerated people, there was literally over 100 people sitting on death row who was cleared. They were completely innocent, right? And those victims' families in the murder of their murdered loved one that they were accused of killing, they believed that they were guilty because the state convinced them that they were. So, you can't hate on the O'Keefes, but at the same time, there's not any recognition as the Reeds as victims. The Reeds are victims. They very much are victims. What this has put them through, they have had to take time off of their jobs to sit there in that courtroom. Also, they're not the ones. Keefes are not the ones having to spend millions of everything that they can muster up to try to defend the very life of their child. Okay, the Reeds are also victims. But besides the Reeds and the Keefes being victims, there are many, many other victims when you have this much corruption as the system. Okay, so this is one case out of many. I beg people, please don't just act like this case is nothing. Please don't disregard these people. The Lopalatos matter too. And they didn't get any media attention what was done to them. None. And that's an outrage. I beg you to talk about these people, and they should be approached by documentary makers too, because they never got any attention. How many other people, the poor, the minorities, how many other people are being horribly abused. So I'm going to tell you, please listen to the story of what they did to these brothers. It's horrendous. So this is an action for money damage, which, by the way, he settled out of court. I'll just tell you ahead of time, okay? But they put these boys, these guys, sorry, not these boys, he put these brothers through a trial that they were acquitted, okay? This is how shady they are. This is what they did to him. And then for Lake to dare sit on their trial in the Karen Reed trial and say he don't know what their version of the story is. He testified in their trial. And then he signed a settlement with these brothers after they sued him in federal court after they were acquitted. How dare he say in Karen Reed trial that he don't know what their version of the story is. But that's how easily, with ease, that they lie, right? Okay. This is an action for money damages on behalf of plaintiffs Mark Lopalato and Alfredo Lopalato arising out of the violation of the constitutional rights by Officer Michael Link, Officer Glenn Nix, Officer Errol Lane, Chief Peter Bright of the Canton Police Department. Plaintiffs also allege that the town of Canton had a custom and policy of deliberate indifference to the rights of its citizens that resulted in the violation of plaintiffs' constitutional rights. But right now, Canton is the heart of America, being split right down the middle, and citizens are rising up. One went to the town council and said, hey, we have one report of a police complaint in our department. Well, in comparison to other towns that have minimum no less than 20 in the same period of time. That tells us you guys are not allowing police reports. This case right here is a perfect example of that. And this is what they do to people who dare file a complaint on them. This is horrible. This is tyranny. Okay, jurisdiction is, this is a 1983 case, okay, 42 U.S.C. 1983. And this is jurisdiction statutes that they have to file under, appended jurisdiction. So they're residents of Norfolk County, Massachusetts. Defendant town of Canton is a municipality duly organized under the laws of the Commonwealth of Massachusetts. You got the defendant, Chief of Police, Peter Bright, was at all times relevant to this complaint, Chief of the Canton Police Department, acting under call of law in his suit as an individual, whoop, whoop, that's what I'm talking about, and in his supervisory capacity as police chief. Individual capacity means that because it is a bad faith act, that they cannot be using taxpayers' dollars to get a lawyer. Individual capacity means that any damages will come out of their pockets. Okay, it shouldn't come out of insurance, but wherever state has their own different statutes. In the state of Oklahoma, the state will not cover. It will not cover an employee for bad faith acts, and that's how it should be. Massachusetts might be different. But anyways, they were not sued in their official capacity. They were sued in an individual capacity. Okay, there's a difference there. So it was the responsibility of defendant Bright to properly train and supervise. Michael Link, relative to this complainant employee. Let's just cut to this stuff. This is what happened. Let's break it down, right? Now, this was August 31st, 2002, but this lawsuit comes in a few years after, and that's because of the trial. This came in after the trial, so the clock for statute of limitations operates a little bit differently. Mark Lopalato was sitting in a friend's car in a parking lot outside the Golden China restaurant. And you probably remember this being discussed in the trial. This is the case. Earlier that evening, Mark Lopalato had been in a verbal dispute with several individuals, including an individual by the name of Tim Albert. So this just shows you how they do operate if you mess with one of theirs, right? How they protect each other in very malicious ways. This is a classic example. This case should have been presented to the jury and they should have been impeached. But of course, under Bev's reign, it wasn't. Tim Albert's older brother, Chris Albert, is a childhood friend of defendant Link. Chris and Tim Albert had been drinking at Centerville's bar in Canton. Defendant Link was drinking at Centerville's that evening as well, and he was drunk too. He was swaying and whatnot. While sitting in the car, now keep in mind, just because he settled out of court, it doesn't, generally how settlements work is they like reserve guilt, like they're saying like it doesn't, like settlement doesn't mean that they're admitting to guilt, okay? While sitting in the car, Mark Lopalato noticed a group of several men leave Centerville's bar and approach the car. At this time, Mark Lopalato exited the car. He was then attacked by several of the men in the group, including Chris Albert. After this attack, Mark Lopalato called his brother Alfredo and informed that he had been physically assaulted by a group of men. Plaintiff Alfredo left his girlfriend's house where he'd been sleeping and came to the parking lot out of concern for his brother's well-being. When Alfredo arrived, he noticed Chris Albert, Tim Albert's brother. Alfredo knew Chris Albert, and so he approached him to inquire about the earlier dispute. So at this time, Lank came from the area in front of Centerfield's bar. He was swaying as he walked. At trial following this incident, Lank would admit that he drank about 4 beers in the 2 hours he was in Centerfield. Lank approached the plaintiffs as they approached Chris Albert. He began yelling that he was a police officer. Now, when he mentions trial, that's talking about the criminal trial that they filed on these two brothers. His breath smelled strongly of alcohol. At the trial following the incident, Lank did testify he activated himself as a police officer at the time. You don't get to activate yourself when you're drunk. If you're even over the limit, you should not be activating yourself as a police officer because you're in a fight. But this is how they work, right? 2 other Canton police officers, Lane and Nix, arrived at the scene. Defendant Lank instructed them to handcuff Alfredo. So Nix handcuffs Alfredo, put him in the back of the cop car. While the other officers were placing Alfredo in the police cruiser, Defendant Lank approached Mark, pushed him backwards, punched him with a closed fist on the side of the face. Plaintiff Mark fell to the ground. Then Defendant Lank landed on top of him. He continued to hit Mark. Then he bit him. Like, if it wasn't enough, you're punching this man while you got him down like this, right? He bit him. He bit the man. And he admitted it too, by the way. Lane pulled Defendant Lank off of Mark. He did not ask Lopalata for any identifying information. He just simply told him to leave. Now, I'm going to tell you right now, if he had assaulted a police officer who activated himself, they would have arrested him on the spot. You don't allow somebody to assault a police officer and then they just go on their merry way. That just tells you right there they lied, which is probably why they were acquitted. So he just told him to leave, like hoping that they just, oh man, you messed up. You shouldn't act like this. You should be beating up on people. Hopefully they'll just go away, right? But they didn't. So while Alfredo was sitting handcuffed in the back of the cruiser, Defendant Lank approached him and spit in his face. So it wasn't enough he beat on him and then bit him. He spit in his face while he's handcuffed. This is who we're dealing with, right? Lank then asked Alfredo who the other kid was. He said, whoever he is, I'm going to make his life miserable. Lank's speech was blurred and his breath smelled of alcohol. This is how they use their power. Even when they're out drunk, they activate their power to be tyrants and beat on people and spit in their face and bite them. Okay. Lank spit in Alfredo's face. Defendant Lane released him from the handcuffs. Lopalato asked, did you see him spitting in my face? Lane responded, just get in your car and leave. Lank drove away despite his obvious intoxication. So, of course, he's driving and drinking. So the next morning, Saturday, August 31st, 2002. By the way, I just have to interrupt right here. Did you all remember the video that I did about the deputy in Massachusetts who was, by the way, ended up at some funeral home after he did a hit and run because he was drunk and there was all kind of beer cans in his police cruiser, and we never got a follow-up did he even face any discipline? He was charged, but they hadn't even disciplined him, right? And we never got the follow-up. I haven't seen it, right? Anyways, my sheriff of my county was just recently charged, and they suspended him. But for other reasons than the charges. So it's not like a given that they remove them from power just because they're charged with something, innocent until proven guilty. However, they generally put them on leave at the very least. Some kind of discipline, something. I mean, you got cans of alcohol in your car. That alone should have been enough for a discipline. Anyways, off we go then. Next morning, Saturday, August 31st, Alfred went to Canton Police Station. Here we go. To make a complaint with Internal Affairs on behalf of his brother and himself. He was sent away and told that he would have to come back on the following Tuesday. But there's a reason why they did that. So they can have time to file charges on him. Okay. So on August 31st, they go in and try to file charges. They send him away to come back on Tuesday. So Alfredo asked Mark if he would go to the police station on that date, because Alfredo would be working. So police reports regarding the incident were not drafted or filed until September 2nd. This was only after Alfredo went to the station on August 31st. Now, if you commit a crime in the presence of an officer, especially if you're assaulting an officer, you're arrested on the spot. But he wasn't. So this was so obviously drafted after he tried to file a complaint. Okay. which thankfully they were acquitted. Only after Alfredo went to the station on August 31st to complain about the conduct of the officers, but these officers were never charged. And so here you have, years later, this officer who's committing perjury in a murder trial, who is the one who's filing these affidavits and reports that ends up in a grand jury indictment of an innocent woman. This is a classic example why these officers right here should have been removed from power, right? They assaulted them, they bit them. Nobody from Internal Affairs went and got the footage of all those places to see if they had cameras, to see if anybody caught what happened, beating them and biting them. And anyways. On the following Tuesday, September 3rd, Mark went to the Canton Police Station to make a complaint on behalf of himself and his brother. He spoke with the sergeant, described the officer's conduct in the incident. The sergeant told him he would get back to him regarding his complaint. That evening, someone from the department called Alfredo and stated that she would look into the complaint. To this day, neither Mark nor Alfredo has ever heard anything from anyone in the Canton PD regarding the outcome of any investigation into their complaint. So if you recollect that there was a man at the city meeting or whatever complaining that there wasn't any history of any complaints in this town of Canton compared to all the other towns who have at least 20. It's common that you're going to have complaints, and if you don't have complaints, it's a problem. That's what he was saying. They're just like, look, that a lot of people are complaining about corruption, then why aren't there should be complaints sitting? There's zero, right? It's because if you try to file a complaint, they're going to get you, right? Soon thereafter, both Mark and Alfredo received a summons in the mail to appear in the court on September 25th. They'd been charged with assault and battery on a police officer. If they had done assault and battery, you would have arrested them on the spot. This is such bunk. Such bunk. Anywho's. On the evening of February 6th, Mark and Alfredo were inside a mobile gas station in Canton. Their other brother, Chris Lopalato, and several other individuals were waiting for them in a vehicle outside. Defendant Link entered the store and asked Mark how he was doing. He said, not so good, you attacked me, and now I'm the one who has to go to court. So here's Link going in the store, running his mouth after he done beat this man up, bit him, spit in his face. Mark and Alfredo Lopalato went outside to get in the vehicle. Suddenly, several cruisers appeared. Link then orders Mark to get into his cruiser. While in the cruiser, Link asks, can we talk about this now? When Mark did not reply, Link placed him under arrest and instructed another officer to take him to the station. So he was booked, held at the police station, released at 3 a.m., arraigned the next morning following charges threatening, disorderly conduct, and intimidation. On October 23, 2003, after a 3-day jury trial, they were both found not guilty of all charges arising out of the August 31st incident. This is the incident that Link sat there. IRL said he don't know what their version is. Can you believe this? Like, when you're hearing about that for the first time during the trial, you have no idea, you don't really know what he's talking about. Now, can you see how incredulous it was for him to sit there with ease and lie under oath, committing perjury, that he had no idea what their version was? He knew exactly what the version was. This is a lawsuit in federal court that he was sued. And they had a trial. And they told their side during the trial. Right? He was cross-examined over the incident of what they are saying. He knew exactly what their position was. But he, in that Karen Reed murder trial, lied. It's relevant and it matters so much. All the charges rising out of the February 6, 2003 incidents were dismissed at the arraignment that same morning. The assistant DA, who handles the matters, apologized to Mark and stated that after the October trial, he realized that defendant Link was a liar. Now that's according to them. As a result of the defendant's conduct, he suffered physical injuries, humiliation, embarrassment, and emotional distress. He suffered, both of them did. So this is where they come in and they sue them under the 42 U.S.C. 1983. And, and so this case, all right, was settled. This was settled. They settled out of court. And if you remember what Link said on the oath, that he signed a non-disclosure, which all that means is you don't talk about the settlement. But for him to sit there, he changed the subject real quick after he sat there and said, well, I don't know what their version of the story is. I have no idea. And so that's when, the lawyer said, well, look, you don't remember the lawsuit? And then when he realized that he was going to bring up the lawsuit, then he switches gears, changes subject, talks about non-disclosure. No, you don't get to pretend like you didn't know anything about it. if he was trying to use non-disclosure, just say, well, I signed a non-disclosure, so I can't discuss. Or if he felt that he couldn't discuss it. And yes, you can discuss it. And all he did was sign a non-disclosure, which is standard for any settlement, to not talk about the settlement itself. But the version of events, yeah. Anywho, so yeah, they settled out of court. So I'm just saying that there are so many. If they're doing it to one, you know what they're doing it to others. That's the bottom line. And so I know there's probably a lot of people that can come forward, and I just pray that cop who said that he saw Higgins at Karen Reed's trial. I want to hear more. I want his name. I want to know why the feds are not taking his testimony. I know that there's 42 minutes of footage missing, and they had her car in the Sally Port. And anyways, so I just ask you to share these guys' story. I think that these guys, I hope they get an opportunity to tell their side of the story, because there was no media. Nobody ever came to these guys when they won their lawsuit. I know maybe they signed a non-disclosure, but they went through a trial. Where was the media when they were saying that there was cover-ups, that the cops were lying, that they were falsely accusing them? Where was the media then? No, it wasn't a murder trial, but they didn't get any media attention. They didn't get, what I'm saying? It's like, I don't know, the media cherry picks when they want to even discuss if cops are being accused. And the media is part of the big problem. The mainstream media, especially the 71 count federal charges filed in January 2024 against Massachusetts state troopers, both past and present, who in that document shows text messages of promising the golden treatment to issue, different types of licenses. And there were people saying, take care of my trooper brother, take care of my cop friend, and those names of troopers and cops who were getting the golden treatment and given bribes, their names were redacted, and they shouldn't remain in power because they're in a conspiracy and a scandal of criminal activity, and they shouldn't remain in power. And they could very well be some of those who testified in this murder trial, and Karen Reed doesn't know because they withheld that, and the mainstream media made darn sure that they didn't cover that or let anybody know about that. And when I specifically tried to discuss that in chat, NBC 10 Boston, in the live stream during this trial, I showed in a video where I was in another browser where I'm not signed in, so that I can see what is, when I comment, if it's actually going through, because they were deliberately and willfully, anytime that I comment specifically about that case, they would block it because they don't want the viewers to know. The media doesn't want the viewers to know of that corruption that the FBI revealed. And it's not like something that the FBI doesn't want the public to know, because it's already been discussed once in one. It was announced in one media, but these local medias are blocking the public, especially with people out there right now. They don't want to feed the fodder. They don't want to oh my gosh, if they found out about this, it would really get bigger. Oh yeah, so they would make darn sure that they was not allowing me to comment that, and they just did that, so, but they are willfully trying to prevent the public to know about that case. 71 counts of conspiracy, bribery, extortion, yeah, and falsifying records. Okay, and then they sit there and act like, oh, is this really cops? They're really corrupt. But then they don't want you to know about the Fed's case against the state troopers, who are very much at the heart of the argument of corruption in this case. So that's it for this one. I hope you have a good day. Bye.